Hey, Amicus listeners. Before we start the show, I wanted to let you know about a story coming up a little later. It's from one of our partners, SAP. AI comes at you fast. If you don't get reliable and relevant advice, your business might miss out. Whether you're looking to automate tasks or embed AI in your business processes, SAP can help. To learn more, head to sap.com/AI and stick around for expert advice on how to embrace AI with confidence.
There was a time when summer surprised us, when galleries opened minds, adventures opened hearts, and we all remained open to whatever the day might offer. It was a time to enjoy. It was summer, this summer, at Biltmore. Plan your visit or overnight stay so you can enjoy the marvelous works of Chihuly and savor the season. Reserve now at Biltmore.com.
There are thousands of decisions in the lower courts that have relied on Chevron. What happens to them? One way of putting what the court is doing is it's just serving as the vehicle to deliver those benefits to the billionaires, right? Could be any of the branches of government. Right now, it's the Supreme Court.
Hi, and welcome back to Amicus. This is Slate's podcast about the courts and the law and the Supreme Court. I am Dahlia Lithwick, and these are the things I cover at Slate. As the dust of the Supreme Court's end-of-term kind of whirlwind settles, we could probably do a whole show or even a whole season about any one of the really big cases that came down in the blur of the last weeks of June. And we're going to be covering their ramifications for months, if not years to come. But this week, we wanted to circle back to a series of cases that we covered individually. And these cases taken together are going to represent a kind of soup to nuts overhaul of how industry and commerce are regulated. And therefore, they're going to represent a soup to nuts of how safe your food, your drugs, your air travel, your water, your saving and investments, your car really is. The biggest and highest profile of this clutch of cases was, of course, the landscape-altering Loper Bright, the blockbuster that came down in the final days of the term, overturning Chevron, which is a 1984 administrative law decision that has really shaped how American life itself and governance has gotten done for the past 40 years. But a part of this mix of cases includes Jarkissi and Garland versus Cargill and, of course, Corner Post. And those case names probably don't evoke much for you right now, but trust me, by the end of this episode, we hope they really will. We wanted to revisit this whole prickly thicket of administrative law because it's both so central to how American government is done, and it's also very impenetrable. So in order to dive way down on what happened in Chevron and those other cases, we invited Lisa Heinzerling back. She is a professor at the Georgetown University Law Center. She served in the EPA, and we wanted her to just take us to school in what we're going to call on this show Admin Law 101. Lisa was with us a few weeks back to help us understand Jarkissi, but we really still need to kind of rattle her brain and help us understand the terms. So Lisa, welcome back. Thank you for making a quick return. And I wonder if we could just start by sketching out the field. Maybe, can you just give us like day one of admin law when you're trying to explain to people the rise of the administrative state and regulatory agencies, and just walk us through what drove the rise of these agencies? What do these alphabet agencies do, and why do they do so much of the bulk of the regulatory work right now?
Administrative law is all about the agencies. Administrative law is a subject that governs the work agencies do and how they do it and how they're supposed to come to their decisions. So it's a huge field. It governs all of the agencies in the United States. And so most people, even without ever knowing about administrative law or what an agency is, have run across the work of an administrative agency in either the drugs they take, that would be the Food and Drug Administration, the air they breathe, that would be the Environmental Protection Agency, the investments they make, perhaps they buy stocks, that would be the Securities and Exchange Commission, on and on down the line. Agencies are basically used by Congress when it passes statutes to implement Congress's direction. So you'll often hear about the administrative state. You'll often hear that the president is going to go it alone without Congress or act alone or use an executive authority. But that actually almost never happens. That's very rare. What the bulk of agencies' work actually starts with Congress. Congress creates an agency like the FDA or the EPA, funds the agency, and gives the agency instructions about what work to do and the parameters for that work. And so administrative law basically governs that relationship. It also provides for court review, judicial review of agencies' decisions. And so the term that just ended really continued a trend that's been going on at the Supreme Court for a few years now, which is really, I think it's fair to say that the court is either dismantling or destabilizing the administrative state. Certainly destabilizing it, but I think dismantling is a fair word as well. And what the court's doing is it's taking aim at the structure of the agencies, the way that they interpret those laws that Congress passes, and the way they need to go about their work. So let me say one word about each of those. On the structure of agencies, what the court is doing is it's trying to make the heads of agencies and even judges at the agencies more responsive, essentially, to presidential both appointment and removal. And so bringing the agencies closer to the political apparatus of the government. And that may sound kind of technical, but it's really important because one of the reasons we have the agencies, think about the agencies I mentioned, the FDA, the EPA, the Securities and Exchange Commission, those are given those jobs partly because they have experts on the subject matters they deal with. So that becomes really important in administrative law to oftentimes Congress will decide to make them independent of the president. And that's one of the targets of this Supreme Court. And that's effectively one of the issues in the Jarkissi case is who has to decide whether someone violated the law. Can the agency do it with its own judges or do the federal courts have to do it? And in that case, they said the federal courts have to do it. The second big issue has been how do agencies interpret their statutes, right? They're given a statute that tells them you should clean up the air, you should make sure drugs are safe, you should make sure that the cars that people drive are safe. And they say that to the agency, that's your mission, and here are some parameters for that work. And for so many years, for 40 years, and I would say longer than that, the courts really deferred to agencies. If they had an unclear statute, a statute that just, you could sort of hard to figure out exactly what it meant, then the agency's view of that statute would prevail as long as it was reasonable. And so this is the piece of the process I mentioned before, which is judicial review. If an agency makes a decision and says, we're making this decision based on this understanding of the statute, for many, many years, courts would say, all right, if the statute's unclear, then the agency really gets to make the call. As long as it's reasonable, it makes the call. And that's what went by the boards in the Loper Bright case you mentioned at the outset, Dahlia, which is that the court overruled that deferential principle announced in a case called Chevron and replaced it with a court-centered kind of interpretation. The courts figure out on their own what the best interpretation of a statute is. And then just the last piece, because there's activity here too, agencies alone among the institutions of the federal government have to actually explain themselves when they make a decision. And when they explain themselves, they have to do so in a way that people can understand and follow and understand why they did what they did. It's not remarked on a lot of times in public commentary on agencies, but it's kind of a wonderful feature of the administrative process, which is that the agency explain itself to the public in terms the public can understand. Now, if the courts drill down too much on the agency's explanations, it becomes just a way to undo a lot of agencies' work, right? And that is a separate case this term, a case called Ohio versus EPA, in which the court rejected an EPA rule on interstate air pollution because it thought that EPA hadn't explained itself well enough. And that tightening of that requirement of reasoned explanation, I think, is going to come back to make agencies work a lot harder. And I think all this work is occurring, in my mind at least, as part of a kind of anti-regulatory campaign on the part of the justices and even some lower court judges. They don't like how much power those agencies I mentioned have, and they're taking it away.
Maybe one little note on what you just said, but I think it's important, is that we tend to timestamp, because we timestamp the Chevron case, which we're going to talk about in a second, at 40 years ago. Sometimes we think that, the advent of, regulatory law is 40 years old, but it's worth saying these are sort of post-FDR New Deal efforts, right? Social Security Administration, the EPA were essential to the sort of welfare state, the regulation of industrial pollution. It is true that Chevron goes back 40 years, but the administrative state is older.
Absolutely. That is the story. If you take most administrative law courses, what you hear is it began with the New Deal. I think that's false, actually. I think it certainly ramped up during the New Deal. We had a lot of crises. We had a president who wanted to take them on, to try things, to solve them. But even before that, presidents from the very beginning and Congress relied on administrative agencies to do the daily work of government. Right? Certainly there are more of them. Certainly we have different problems, but it's not at all new. It's not at all a new phenomenon to have Congress realize it can't do everything itself. It needs to delegate authority to other institutions, these are the agencies, to do, as I say, the daily work of government, to sort of take Congress's broad instructions and implement Congress's wishes.
So let's turn to Chevron, because I just want to read you. I love this. It takes a lot to get Barbara Streisand to tweet about admin law, but there she was on June 28th, 5:58 p.m., quote, "The Supreme Court overruled 40 years of precedent and overturned the Chevron decision. It makes judges and the Supreme Court the regulators of laws passed by Congress rather than the scientific expertise at federal agencies. This is not democracy, but rule by judicial order. The only beneficiaries are big business and polluters." Like, first of all, points to Barbara Streisand for nailing what it was that happened in Loper Bright. But I would love to talk about Chevron comes in 1984. It comes down in a very specific political context. It's actually sort of the reverse of the current context, because Chevron was much beloved by a conservative legal movement, right? I think we talked about this when we spoke last, including Justice Scalia, that was trying to rein in the regulatory agencies, and they wanted to keep those meddling kids, the Article 3 judges, out of the hair of regulators. So can you just tell us what Chevron held in 1984 and what that political context was trying to do?
Yes. So Chevron held, consistent with, and this is why I say it really goes back before Chevron, consistent with a long line of cases. The court held that when a statute is ambiguous, when it's not clear, and an agency comes up with a reasonable interpretation of that statute, the courts should give way. The courts should defer to that interpretation. One of the things that Chevron did, and it's significant, and it sounds just stylistic, but it was significant. They really crystallized the idea of deference to agencies in a two-part step. You look to see if the statute's clear. If so, that clear meaning prevails. And then if it's ambiguous, then the reasonable view of the agency prevails. And so that's essentially what Chevron did. But specifically, Chevron itself upheld a vast, massive deregulation done by EPA in the Reagan administration under the Clean Air Act. And so it's a very complicated program, but essentially it meant that many of the largest stationary sources, think power plants and factories, of air pollution didn't need to apply for permits anymore when they were going to modify their facilities. And that meant they wouldn't put on the best pollution control technology, and they wouldn't offset the emissions that they were going to generate as a result of that modification. So it was a really, really big decision in terms of the Clean Air Act. And as you say, exactly sort of the opposite from the posture it was in Loper Bright and so many other cases today in which the court is refusing to defer to a regulatory decision or puzzling over whether to uphold a decision actually regulating rather than deregulating. And for so many years, I mean, as you say, Justice Scalia was the biggest champion. And for so many years, there was just not a peep, really, about how bad Chevron was. In other words, I don't think people were even thinking that. It's not just that they weren't talking about it, they weren't thinking about it. And lo and behold, in the administration of President Barack Obama, conservatives started to say, oh man, Chevron, we didn't like Chevron that much. Here we have a president with an ambitious policy agenda, and we don't like Chevron anymore. So they started to say, oh, this is judges and academics. Not only is Chevron not so good as a policy matter, but maybe it's unconstitutional, right? Violates the separation of powers for judges to defer to agencies. And then some people started to say, well, maybe it violates this single obscure sentence from a statute called the Administrative Procedure Act, passed in 1946. And that statute is the statute that by default governs administrative law, basically. It tells agencies what processes to use, how courts are to review their conduct, and so forth. It's a really important statute. Doesn't govern every agency, actually, but a really important statute. And people started to say, oh, this sentence that's been there all along in the provision on judicial review actually prohibits courts from deferring. It's not just that it, makes it, important that they be careful, what have you. No, it prohibits them from deferring. And in Loper Bright, that's actually the route the court took.
Let's pause for a moment to hear from some of our sponsors.
This podcast is brought to you by Slate Studios and SAP. AI is moving so fast. If you don't get reliable and relevant advice, your business might miss out. Welcome to Dear Artie, an advice column from SAP, where we tackle the tricky questions at the intersection of AI and business. Let's meet our expert.
Hi, I'm Ian Khan. I'm a technology futurist, speaker, and author, and I love to help organizations measure their current state of readiness for an AI-driven world. I'm excited to dive into today's question.
Dear Artie, our finance team is top-notch, but small. How can AI support them? Signed, Financially Drained.
Well, financially drained, a lot is happening in finance and AI, and the possibilities are endless. First of all, AI can help your finance team analyze massive amounts of financial data faster than any human or a team of people could do. Second, it can help perform functions on data through algorithms. This can connect different systems together and really simplify decision-making for your finance team. And last but not least, AI can help reduce the time needed for data to provide insights so that your leaders can make faster decisions.
Embrace AI with confidence. Head to sap.com/AI to learn more.
This is Dahlia Lithwick from Amicus. Just pointing out, in case you didn't know, how much legal news is coming at us right now, whether it's Donald Trump or Hunter Biden or the full-scale Opinionpalooza that is the end of the term at the U.S. Supreme Court. Here at Slate, Amicus and What Next have got you covered. What Next is Slate's daily news show featuring breaking news analysis with experts and with the people who are living the headlines. The consequences of decisions made in a hushed courtroom at 1 First Street in Washington, D.C. will reverberate all around America. And what next is going right to those who are most affected. From a grieving mother fighting to settle with Purdue despite her son's death, to an Idaho physician taking care of women who need life-saving abortion care. What next is asking, how will these rulings change lives, and whose lives are they going to change? If you haven't heard one of Mary Harris's spectacular interviews, her style is warm and incisive, curious and open-minded. Get ready to hear some stories you have not heard before, or to hear a different side of a story you thought you already understood completely. So we've got you covered with Amicus's Opinionpalooza coverage and What Next's news coverage. You will have the context you need this June. On Amicus, we're going deep on the cases that are changing American lives. And on What Next, Mary Harris cuts through the noise so that together we can all figure out what's next. Follow What Next now and listen wherever you get your podcasts. More now with Professor Lisa Heinzerling on the destruction of the administrative state and what it means for you. I'm going to ask you to wear your law professor hat for just one more minute in sort of explaining the landscape, because Loper Bright is an important case, not just for what it does, but kind of for the transition of what it started as and what it became. And I think that Loper Bright is an important case in describing, what Professor Steve Vladeck always talks about in terms of, how the court controls its docket and how it plucks out a case that purports to be about one thing and then rewrites the question and turns it into another thing. So this is a kind of a obscure, possibly moot case about fishing boats and government monitors and who pays for the monitors and how to interpret guidance from the National Marine Fisheries Service. We did an episode when Loper Bright was first argued, and it's really, I think, unbelievably essential to understand that there is a power grab by the courts simply when they rewrite the question. So can you just walk us through sort of where it started and how it's going?
Yes. An agency, the National Marine Fisheries Service, had decided to require commercial fishers to pay for monitors that the agency required them to carry occasionally to make sure that they're complying with rules for fishery management. A lot of our fisheries are in trouble. Many of them are collapsing. A law called the Magnuson-Stevens Act tries to ameliorate this situation. And so one of the ways that the agency thought wise to start improving the situation with respect to fisheries was in one fishery, again, to require not only monitors on board occasionally, but also the fishers themselves to pay for those monitors. Not a big rule, right? One fishery, and it wasn't even in effect or being enforced at the time this case came up. The agency had run out of money to run the program. It wasn't enforcing it. It had operated for 1 year. It cost a total of $23,000 for that year, and all that money was refunded. Not even clear that the fishers who challenged the rule in that case ever spent any money. They have no allegation to that effect, no allegation that they were ever required to take a monitor on board. And so it's strange that the Supreme Court would take this kind of really minor rule, never enforced against these parties, as far as we know, not in effect, and use that as the vehicle to overrule the most important case in all of administrative law. Just strange. Becomes a little less strange when you realize that the parties were basically, their lawyers are funded by billionaires. And so it's not at all a stretch to think that this was a case with nominal plaintiffs that don't have any apparent injury, actually, as a consequence of this rule, and brought in order to satisfy the interests of much bigger fish, if you will. So that's the background of the case. The other thing is, At oral argument, the justices also made a big deal out of the fact that these were small business people. They were the little guys, right? And so it was important to them to sort of highlight that fact. Less well known is the fact that the Fishers actually took two questions to the court. One was, you should decide whether to overrule Chevron. Two, you should decide what this statute means for these Fishers, right? And the Supreme Court decided, no, we're just going to decide the question about Chevron, not the question about what this statute means. So at the end of the day, the court didn't even decide the case involving the controversial Fishers. That goes back to the lower courts. So they don't even get a judgment in their favor in the sense that they still don't know whether the statute covers them. And so all the way around, it's sort of a made-up case with a nominal plaintiff with no injury that comes up to the court at the behest, effectively, of billionaire-funded lawyers. And by the end of the day, the Fishers' actual claim is left on the cutting room floor.
Yeah, I think it's really important that they get no relief in this case. They always find the sort of mom and pop beleaguered industry, and unerringly, it's kind of like the billionaires who sail off into the literally sail off into the sunset in a case where the, Fishers who had at least a plausible claim that this wasn't fair get no adjudication on the merits at all. You started to talk about this, Lisa, but I'd love for you to develop a little further. I feel as though we've now inured our listeners to being afraid when I ask you a question about the Administrative Procedure Act. But you make the point, and I think it's really central to understanding, that the APA becomes the cornerstone of Chief Justice Roberts' majority opinion.
Yes, it's so important. So the court was asked to hold that this Chevron principle violated the Constitution, that it violated the separation of powers, that is the division of power between Congress, the executive, and the courts. And that's been an argument for a long time against Chevron, again, since about the administration of Barack Obama. So they could have decided that. And indeed, Clarence Thomas and Neil Gorsuch, in separate opinions, said that they believed that Chevron violated the separation of powers. Now, what would that mean? That would mean that even if Congress wanted to change the interpretive principle as the Supreme Court saw it, it wouldn't be able to. If it violates the Constitution for courts to defer to agencies' interpretations, then there's no fixing it in Congress. And what the court did instead is it said, it starts with this long exegesis, this long discussion of what courts normally do and always have done, in its view, with respect to interpreting statutes. But that doesn't actually decide the case. It's this long kind of constitutionally inflected discussion. But when it comes to saying, why is it that legally Chevron was terrible? Why is it that Chevron itself was unlawful? It turns to the Administrative Procedure Act, which I said is the default kind of governing framework for administrative agencies' work. And it turns to specifically one sentence in that statute, and that sentence is talking about how courts are to review agency actions of various kinds. And that sentence says, the reviewing court shall decide all questions of law. It has other things in that sentence, but that's the key point. That's the key passage. The reviewing court shall decide all questions of law. And the court thought that means, and has meant for 80 years since the Administrative Procedure Act was passed, that reviewing courts may not defer. Congress told us reviewing courts may not defer. They need to be the ones to make the interpretation. And they don't do that if they defer to an agency's view. That's quite astonishing in a number of ways. It's noteworthy they didn't decide on the constitutional basis. It's also surprising that they would find that authority for them to undo Chevron in an almost 80-year-old statute that has never been understood that way. Right? It's never understood that way. And it's a little bit reminiscent. A couple of years ago, the court created something called the major questions doctrine, where it said that if an agency is making a decision of great economic and political importance and interpreting a statute to allow it to address an issue of that magnitude, Congress needs to have spoken really clearly, super clearly, before the agency is allowed to address that kind of an issue. And the court said, we really think that if a statute's been around a long time and the agency has never exercised this authority, that's really a sign that it doesn't exist. Well, one could say that about the Administrative Procedure Act and the Loper Bright case. This is a statute that's been around, again, for over 80 years. Nobody has understood, or almost 80 years, nobody has understood the statute this way. And it doesn't have to be understood that way. A court can decide a question of law about a statute's meaning and still give deference. It's still deciding that whatever the agency did fits within the broad parameters of the statute.
So this actually comes up at oral argument in January, where the Solicitor General, Elizabeth Prelogger, starts to warn the justices that if they overturn Chevron, and let's be clear, this is like Dobbs, that we've had lower court reliance on Chevron for a really long time. And what she warned at the time was that throwing it out could lead to having to reconsider a whole panoply of other cases. She said at the time there's about 80 cases out there that need to be challenged if you're going to do away with Chevron. And we got a lot of like there. But in practice, what was she suggesting is going to happen?
Well, that's exactly right. There are, as like you say, approximately 70, 80 cases at the Supreme Court level that we need to think about. Are those still good law? And the court says, well, we're not disturbing those cases because those cases will still be respected as precedent. But this is in the middle of disrespecting the precedent that underlies them all, right? So there's a certain degree of like really sort of, do you mean it kind of attitude that might inspire. In other words, it's hard for them really to tell us to bank on stare decisis, which is the principle that you stay with precedent unless there's a really good reason not to, that bank on that principle in a case that is disrespecting that principle, right? Also, the Supreme Court is only talking about in those paragraphs where it's saying, don't worry, this doesn't touch our decisions. Well, okay, there are thousands of decisions in the lower courts that have relied on Chevron. What happens to them? It'll be up to the lower courts to decide whether to stay with them. And they might not. I mean, how solid can they be in sticking with their own precedent when the Supreme Court has abandoned its own precedent? So that's a big worry. I'll say even further, if I may, there's another context that I think is very much undermined by the Supreme Court's decision in Loper Bright. In addition to the principle that courts are supposed to defer to agencies' interpretations of statutes that they implement that are passed by Congress, there's also a principle that courts defer to agencies' interpretations of their own regulations, right? It's a principle called Auer deference, AUER, if you want to imagine the case. That's the case one of the cases it came from. And I think that the Loper Bright decision really undermines the basis for that kind of deference as well. So because given the theory of the Administrative Procedure Act that the Chief Justice is working with, that reviewing courts decide all questions of law, that would equally undermine the principle of deference to agencies' interpretations of their regulations.
Yeah, this is a piece of it that I think slid out in the initial reaction to Loper Bright, which is this is not just doing violence to Congress's ability to regulate. This does violence to the agency's ability. I mean, it's really a kind of 1-2 punch because it's arrogating power both that is conferred upon Congress and that is conferred upon the agencies. And that's a really good way of explaining it, that it sort of leaves open that the courts can just, kind of pick through both statutes and agency interpretations of statutes. And really, in both senses, the court is like, we're the decider, right? I mean, this is a huge, huge arrogation of powers that are conferred in other directions.
Absolutely. The whole decision is step aside. We're in charge now.
So you made this point, and it's really important. Again, it has a slight feeling of Dobbs, that what this decision does is it sort of sweeps away 40 years of precedent, and it says, oh, that was all really confusing and chaotic, and this is going to be really simple and clear. But of course, the chaos and the mess that they've now imposed creates new chaos and messes. I mean, there's nothing clean about this resolution. But the good news is when there's more chaos, the court will get to resolve that too. It's an infinite sort of loop of the court saying, like, wherever we sow and foment confusion, we'll be back to sort it out. But one of the very important pieces that you pointed out when we were talking about this case last week is that the Clean Air Act is kind of separate and apart from all the confusion because Loper Bright relies on the APA judicial review provision, like you said, but the Clean Air Act expressly says that 706, that judicial review provision, does not apply to most of the EPA's regulatory actions. So we've got a weird carve out for the Clean Air Act that may leave the Clean Air Act not subject to whatever just happened in Loper Bright?
Yes. So, as I said, the Supreme Court relies solely for its legal argument that Chevron is unlawful. It's solely on the Administrative Procedure Act, and particularly one sentence. And Congress, in the Clean Air Act, in amendments in 1977, said that the Administrative Procedure Act doesn't apply on judicial review of agencies' rules, and lists a whole bunch of different kinds of rules, but effectively it doesn't apply for many of EPA's rules. And instead sets forth a number of standards of review, like it can be an agency decision can be undone if it's arbitrary and capricious and so forth. What it doesn't include from the Administrative Procedure Act is that sentence that talks about the court shall decide all questions of law. Doesn't have that. And indeed, this was on Congress's mind at the time. They actually had considered a statute that would have created de novo review for agencies' rulings.
Explain de novo review.
It's essentially what we have under Loper Bright. The court just takes it on itself, doesn't give any particular deference either to a court that decided it before or to an institution like an agency. It's whatever the reviewing court takes it afresh without special regard for other decision makers. And they rejected that. Congress rejected that. And this is all set forth in a really great amicus brief by a lawyer named Sean Donahue and other wonderful environmental lawyers. And they go through that history and they say the APA doesn't apply to everything. And in the Clean Air Act specifically, it doesn't apply. And the Supreme Court said nothing about that. And indeed, Chevron took place after that provision was put into the Clean Air Act. Review under Chevron was under that provision. And nevertheless, the Supreme Court and Justice Gorsuch, in his separate opinion, chides the Chevron court for not talking about the Administrative Procedure Act. Well, it didn't apply to that case. And the Administrative Procedure Act doesn't apply to review of all those really important agency air pollution rules that are moving through the courts now. And I just think there's a very plausible legal argument that Loper Bright should not apply to Clean Air Act cases because of the ousting of the Administrative Procedure Act in that statute and the very different wording of that statute. I'm not saying Chief Justice Roberts will agree, but he has to have a reason for that, and I don't see the reason.
We are going to take a short break. Let's return now to my conversation with Professor Lisa Heinzerling, formerly of the EPA, currently of Georgetown Law Center, as we try to survey the smoldering wreckage of administrative law. So we're going to do one more fun doctrinal thing, which is you're going to explain corner post because it comes down the same day as immunity. And it absolutely got lost in the shuffle. And in a lot of ways, Lisa, corner post kind of puts all this on steroids, right? It's sort of nominally a statute of limitations issue. But as you said in a piece you wrote for Slate, it actually really hypercharges this deregulatory phenomenon that's unleashed earlier in the term.
Absolutely. So there are deadlines for filing challenges to agency rules, and statutes can set their own deadlines, but the review that takes place under the Administrative Procedure Act, which we've heard about quite a lot so far, that statute says you need to file within 6 years of the time the action accrues. And the Supreme Court said that an action accrues not when the action becomes final, not when an agency issues a final rule, it's effective, and then you have 6 years to file a challenge. That's the approach taken by all the lower courts, and that's the approach that makes some sense so that you can actually have some finality and know after 6 years, we know the legal status of this rule. What the Supreme Court said instead is it accrues when a party is first injured by the rule. And in that case, it was a truck stop that was incorporated after the 6-year statute had passed, but was only injured when it became incorporated. And the court said, you can sue. And that sounds, again, may sound kind of arcane, maybe even a little dull. It's hugely important. Why? Because the court has just fundamentally changed the way courts must review agencies' understanding of their own laws. And it said, and by the way, if you're newly injured, you can sue at any time as long as it's within 6 years of your injury. So you can, as in court or post, incorporate a new company, for example, and then say, hey, we're injured now, and so we want to sue. In those cases, it's just hard to imagine a court with a new lawsuit applying Chevron. Because they don't apply the new interpretive principle that the court has come up with in Loper Bright. And so even now, I know that industry lawyers are combing through the Federal Registers, that is the sort of daily newspaper, if you will, of the federal government with all the rules and announcements of rules in it. They're combing through that, going back probably decades to find rules that they either didn't challenge because they thought they'd lose under Chevron, or did challenge and the agency won under Chevron, and thinking, you know what, we can file new challenges.
How does that impact things like the mifepristone decision? There was no decision. They decided at the end of the day to not decide. But how does this changing of the statute of limitations affect MIFI?
It's so interesting and troubling because in the mifepristone case, as you know, the anti-abortion parties had challenged even the original 2000 approval of mifepristone. And the only reason that didn't get brought up to the Supreme Court or wasn't an issue at that time is the Fifth Circuit said, no, you're out of time. It's way past the statute of limitations for that challenge. Well, it's not anymore. Right? It's not anymore after Corner Post. And the same law firm that represented the little truck stop in Corner Post has represented parties in cases involving reproductive rights. And so I don't think there's any chance that they didn't know the relationship between those two cases. And I'll be surprised if there isn't a fresh challenge to that original approval of mifepristone in the case that the court can cite in accepting it as Corner Post.
You know, Justice Kagan has been sounding the alarm about what's going to happen to Chevron and the kind of hungry hippos approach to admin law. In Loper Bright, Justice Kagan writes, quote, in one fell swoop, the majority today gives itself exclusive power over every open issue, no matter how expertise-driven or policy-laden, involving the meaning of regulatory law. And then I think in the sort of gut punch sentence, she adds, as if it did not have enough on its plate, the majority turns itself into the country's administrative czar. And I always, in my head, I hear the echo of Kagan writing in a 2019 case where she really warned us that if this incredibly narrow view of agency authority were to be allowed to prevail, she wrote, quote, most of government is unconstitutional. Can you sort of tie together this theme of judges as kind of free-range administrative czars? We saw it in the Ohio EPA case. We saw it, I think, in the bump stock case. You know, we're seeing it in the mifepristone case. And all of these cases, we mentioned jarcossy, we mentioned the Clean Air Act case from 2 years ago, Clean Water Act case from last year. It feels to me, and this goes back to your very first point, that if agencies have both the ability to be replaced electorally, right? That's the idea, that if you hate what the EPA is doing, you can vote them out. But also they have expertise and they can act nimbly. And that, as you said at the very beginning, Lisa, they have to explain themselves. Now it just feels like this term in the aggregate is just a huge invitation for not just endless, infinite litigation, but endless, infinite judicial sort of supplanting of information, of knowledge, of expertise, of science with kind of their own feelings, and that only ratchets in one way.
Yes, that last part about ratcheting in one way is really important because Chevron itself could go both ways. It became more deregulatory in its later years, but it could mean that a president of either party could really make a mark in terms of regulatory policy and their own political agenda of either party, right? But today, the combination of the courts being in charge and the courts being motivated by really an anti-government impulse. That kind of theme and mood runs through these cases. This distaste of the so-called bureaucrats, this distaste of the agencies, and underlying it, less explicitly acknowledged, but also true, this distaste of Congress. So that they are really putting themselves in charge, and putting themselves in charge, not only citing some words in the APA or the Constitution for this proposition or this power grab, but also really sending a signal with their attitude towards government. They don't like government very much, it seems. They really are creating chaos in some of these decisions, but not allowing anybody to create order.
And this is just a nitpick, but is one of the fixes, assuming we can't do like structural court reform in the next 5 minutes, that Congress could codify Chevron again by just rewriting the Administrative Procedures Act and making sure that that ambiguity, which, as you said, didn't exist until it existed, can that be fixed if Congress could fix things?
Technically, you should be able to draw that conclusion from Loper Bright. As I said, they didn't rule on constitutional grounds. They ruled on the grounds of what the APA says. So it's plausible to argue Congress could fix that. And they wouldn't need to actually recodify all of Chevron, the whole precedent around it, every single detail, right? But to give some deference to agencies and their interpretations. In principle, Congress can do that. My worry is that the mood of the court and some of the lower courts is such that they won't allow it, right? Chief Justice Roberts has an idea about what courts do and what courts have always done and what courts appropriately do. And that may not have been part of the so-called holding or the reason for the legal determination he made, but boy, is it part of the background. And I do worry that they might take aim even at a new statute that codified Chevron. Doesn't mean that they shouldn't try, doesn't mean that it'll happen for sure, but the mood is unmistakable.
I want to just note that my friend Mike Podharzer made the good point when Loper Bright came down, that there is this intimation that this is a huge power shift, away from federal agencies, away from Congress, and into the laps of the court. But in a sense, when the courts grab power from the agencies, the big winner isn't just the courts, right? If you're really talking about how we're going to address the climate crisis and food safety and homelessness, as Justice Sotomayor brings up in a case about why people are sleeping in parks, and clean water and transportation safety and drug regulation, it's not as though the ultimate regulator is the courts. In some sense, the real beneficiaries are the billionaires who pretty much will dictate what those future regulations look like. In other words, this is conferring power nominally to the courts, but isn't it really just conferring power on industries and corporations that are going to be able to use huge financial advantages to dominate the regulatory and rulemaking and enforcement process. This is not just a win for the courts. This is just a big win for the folks who didn't want to be regulated and are kind of going to be writing their own rules.
It's a really good point to end on that and really emphasize it. And one way of putting what the court is doing is it's just serving as the vehicle to deliver those benefits to the billionaires, right? Could be any of the branches of government. Right now, it's the Supreme Court.
To our listeners who were depressed and worried about what Loper Bright did, at least now you're probably more depressed and worried, but like deeply, deeply informed about admin law. And that is the goal of the show. Lisa Heinzerling is a professor at the Georgetown University Law Center. She served in the EPA, and I think this is really one of those issues. I mean, we've been wanting to talk about admin law for years and years on this show, but like worried that it couldn't be made real. But I think you have really, really, both in your writing and your helping us understand this in the 2 episodes we've had you on, Lisa, made very, very tangible what feels like a kind of, as you say, nameless, faceless bureaucrat government abstraction. This is, in fact, not an abstraction. This is as materially relevant as, the food we eat, the drugs we take, and whether planes can fly. So thank you so very, very much for taking a lot of time to make all of us much smarter.
You're welcome. My pleasure.
And that is a wrap for this episode of Amicus. Slate Plus members, there is a fresh new bonus episode waiting for you right after this one. Mark Joseph Stern is making his final appearance at the Amicus Plus cigar bar before taking some well-deserved parental leave this summer. Together, we're going to answer some of your letters and your questions. And my God, listeners, you are smart and curious. And there are questions on everything from bump stocks to vasectomies. Smart, weird, we love you. If you are not a Slate Plus member yet, but you'd like to get access to our bonus episodes here at Amicus, never hit a paywall at slate.com. And if you would like to listen to all of Slate's podcasts ad-free, go to slate.com/Amicus Plus. Or if you're listening in Apple Podcasts, hit try free at the top of the show page. We will see you in the cigar bar right after this. And thank you, Slate Plus members, for making it possible for us to do the work that we do. Right. Thank you for listening. And thank you for your letters and your questions. You can keep in touch with us at amicus@slate.com. You can always find us at facebook.com/Amicus Podcast. Sarah Birmingham is Amicus's senior producer. Alicia Montgomery is vice president of audio at Slate. Susan Matthews is Slate's executive editor. And Ben Richmond is our senior director of operations. We'll be back with another episode of Amicus next week. Until then, hang on in there.